Previously on Drugs on the Docket.
In a stash house sting, you have federal law enforcement officers creating a crime and choosing individual people to commit that crime, targeting individual people on that crime. 92% of the people who the feds target to commit this crime are people of color. There's these really long mandatory minimum prison sentences attached to every single case. And it's even possible to get life in prison, mandatory life for this entirely made up crime. Our litigation shut down this whole stash house operation in Chicago. Federal prosecutors stopped bringing these cases. And then I've also heard from a very reputable source that at this point in time, the operation has basically been shut down nationwide. And I have personally not heard of a new stash house case in a number of years. And no one has, actually. We've been keeping our ear to the ground and we haven't heard of anything.
The litigation conducted by the clinic and the Chicago Defense Bar in the Seventh Circuit Court of Appeals resulted in reduced sentences for their defendants, with many being sentenced to time served and subsequently released from supervision or incarceration. But as Alison pointed out in part 1 of our 2-part episode covering the clinic's work on these cases, there were hundreds of other stash house defendants in the United States federal system serving decades-long prison sentences for similar crimes. One of these defendants was Dwayne White. The stash house stings were supposed to target violent people who were driving gun violence in Chicago, but White only had a minor criminal record. The federal agents did not target White directly. Rather, White was called last minute by a trusted friend, Leslie Mayfield. The two of them were arrested and charged. White turned down a plea deal to serve 15 years in prison, but was convicted at trial and sentenced to 25 years. Mayfield's initial conviction was reversed, and he became one of the 43 defendants in the Chicago criminal class action suit, which you could hear about in part 1. As a result of that litigation, Mayfield was released in 2018, only 6 years after his initial arrest. White, meanwhile, remained behind bars and would not be released until 2030. Mayfield asked Alison and Erica for help. Erica filed a compassionate release motion on White's behalf with a letter from Mayfield. It was me who lured Dwayne into the case. I was standing right next to him when, 2 weeks after our arrest, he was told that he had a child on the way. It's not too late for her to have her father. The motion was successful. Dwayne White was released from an Alabama federal prison in August 2021 and was greeted by his daughter at the airport in Illinois. She was 11 years old. From the Drug Enforcement and Policy Center at The Ohio State University, this is Drugs on the Docket. Each episode will tell the story of how U.S. court decisions impact drug law and policy and continue to shape the war on drugs. I'm your host, Hannah Miller. Today, we continue our coverage of the Seventh Circuit Stash House litigation and compassionate release. If you like what you hear in today's episode, visit go.osu.edu/drugs on the docket to follow the series. The 43 defendants of the Stash House litigation that you represented had not gone to trial yet or taken plea deals already or been sentenced already. So what happened to the other defendants who'd already been moved through the system and were not part of this litigation?
As Alison mentioned, there were 94 individuals who were charged in connection with the Chicago, stash house reverse sting operation. So after our litigation had concluded and all of those, the 43 people who were part of our litigation were sentenced, we knew, because we had been reading about their cases, that there were, about 40 other people whose cases were already closed. Their convictions were final and they could not join our litigation. 40 plus people who are still in prison. They have exhausted, most of their post-conviction remedies at this point, habeas, clemency, direct appeal, and they're serving decades in prison. And so they were without hope at this point. And obviously they were hearing about this litigation that was happening. And there just wasn't anything at that point while we were litigating that we could do. But after it was over, we started to think about, was there anything that we could do? And we didn't know quite what it would be. But I think that is the wonderful part about practicing in a law school clinic and having just come off this litigation where we were really pushing the boundaries, being creative advocates. So in the fall of 2019, my students and I started a project to try to get these 40 plus guys out of prison, if we could, or at least start by trying to get a few out of prison. And the key to all of our work was the First Step Act, which was signed into law by President Donald Trump in December 2018. And this was really the first federal criminal justice reform in decades. Congress finally steps in and makes some really, monumental changes, both to drug sentencing statutes and then also to compassionate release.
Talk us through the First Step Act, because there's a lot going on in that bill.
So the first part of the First Step Act were these once in a generation changes to these draconian recidivist sentencing enhancements that had just for decades produced these breathtakingly long sentences in federal drug cases. And the way that the enhancement worked, and this applied to our, the Stash House clients, if you were charged with a federal drug offense and you had a prior drug conviction on your record, the prosecutors can file a notice to enhance your sentence from a mandatory minimum of 10 years to a mandatory minimum of 20 years. If you have two of those convictions on your record, they can enhance you from a 20-year mandatory minimum to mandatory life. And these prior convictions, prior to the First Step Act, did not have to be serious. For one of my clients, his enhancing conviction was a prior for simple possession from when he was a teenager. And that was enough to take his case and take his, mandatory minimum from 10 years to 20 years. So in the First Step Act, Congress finally recognizes, these sentencing enhancements are extraordinarily harsh. So they changed both the penalties that attach to them and then what kinds of convictions can actually qualify to enhance the sentence. But Congress did not make these changes retroactive.
What did the passage of the First Step Act mean specifically for the Stash House litigants?
Anyone who was sitting in prison with a final conviction could not get any relief at all. And many of this, what we've called the pre-litigation cohort of Stash House guys, the ones whose convictions are final and they're in prison, fell into this category. They had these 851 enhancements that could not be imposed today. So for them, on top of being in prison for a reverse sting based on these fake drug amounts, in spite of hearing that guys who did the exact same thing as them in Chicago, the same playbook, the same prosecutors charging these cases, they're hearing that these guys received sentences of, on average, 2 to 3 years. They are also in prison serving double the time that they would get if they were sentenced today. And Congress's message on that was, tough luck, our changes don't apply to you.
You mentioned that many of the Stash House litigants from the first cohort had exhausted their options for relief. What avenue did the First Step Act provide them?
The second big change in the First Step Act is the change to what's become known in the federal system as federal compassionate release. It's a sentence reduction statute that Congress enacted in the 1980s around the same time that it abolished federal parole. And the statute is really interesting. It's not called compassionate release, even though it's come to be known as that. It is called a sentence reduction statute, and it says that judges may, for extraordinary and compelling reasons, reduce an otherwise final sentence if the reduction is consistent with the sentencing factors and applicable Sentencing Commission policy statements. The problem with this statute from the get-go was that Congress made the Bureau of Prisons the gatekeeper. And for decades, the Bureau of Prisons just refused to open that gate, even in cases where people were sort of the quintessential compassionate release circumstances. Someone has a terminal cancer and they're dying. Even then, the Bureau of Prisons was obstructing this congressionally mandated path for people's sentences to be reduced. The BOP's really cruel handling of this really galvanized advocates to demand reform. And Congress finally delivered by making a really, really crucial change to the statute, In the statute, it said the Bureau of Prisons had to bring these motions, and that was just causing this logjam because the Bureau of Prisons wasn't doing that. So the change that Congress made was saying, individuals can bring these motions to judges after they've exhausted with the Bureau of Prisons. Essentially, they make a request to the Bureau of Prisons. The Bureau of Prisons either doesn't respond or denies, and then you can take that motion into court. And that was a game changer.
I'm sure Congress did not have stash house sting defendants in mind when they created the standard of extraordinary and compelling reasons to justify a reduction in sentence. I'm also confident that anybody listening to this podcast knows I certainly think these are extraordinary and compelling reasons, right? That language is in fact so fitting, and the way in which the First Step Act meant now that defendants could bring such claims directly into court, so powerful against the backdrop of this whole story and the legal standard that exists in the sentence reduction statute.
The interesting, I think, wrinkle about all of this is Congress, in a prior statute from the 80s, had tasked the Sentencing Commission with describing what reasons are extraordinary and compelling in a policy statement. So that was always in the Sentencing Commission's wheelhouse. That was their role. And after the First Step Act, so this monumental statute is passed, it makes these big changes, the Sentencing Commission loses its quorum. And so they are without a quorum, and they cannot update this policy statement, which was based on, the prior version of the law where the Bureau of Prisons was involved. And that created just this really interesting period of litigation around what could be extraordinary and compelling. It became like a laboratory of sorts for what kinds of arguments, were resonating. Like, could something like these circumstances of the stash house, continued incarceration for crimes that were no longer being investigated, and these, massive sentencing disparities, was that extraordinary and compelling? Seems to me that it was. So it was advocates trying out all these different types of arguments, and then district judges and appellate judges having to decide are there boundaries to what can be extraordinary and compelling if the Sentencing Commission has not defined it. And so there were circuit splits about these non-retroactive changes in the law that were passed in the First Step Act, whether those could be extraordinary and compelling. And in the Seventh Circuit, where we practice, it became a very constricted landscape for compassionate release motions and what could be extraordinary and compelling, but that was not the case in other places. So what we decided to do was we were going to bring compassionate release motions and argue that our client situations were extraordinary and compelling for several reasons. The first argument we made was that the fact that they were sitting in prison for these 25-year mandatory minimum sentences for a reverse sting operation that the government had completely changed course on, no longer investigating it, no longer charging it, and essentially had disavowed it, that in and of itself was extraordinary and compelling. The second thing we argued was that these sentencing disparities that were created, and we had this perfect illustration of how extreme and unfair the sentencing disparities were, because we had people who, it was the same playbook, the same story that they, all these people were told in the same area with the same agents, and a whole cohort are in prison and convicted for decades, and a whole other cohort get these time served sentences. They're out in their communities, they're with their families. I think the longest sentence served in that cohort was about 9 years. So just drastically lower. And that the government had endorsed these deals. They'd endorsed these lower sentences, essentially conceding like that's enough time to punish what was done.
Am I wrong to guess the government wasn't as keen to endorse your sentence reduction motions?
No, they were not. And they are still fighting them. I think it's actually shameful that they're doing that. Now, especially that the Sentencing Commission has issued a policy statement, they could support or not oppose these motions, but they continue to oppose them, even though many judges now have determined that these circumstances are extraordinary and compelling.
The motions for compassionate release versus sentencing reduction, are those completely different, or they also relate to stash house cases?
Sorry for throwing out different terms. So these motions are generally like compassionate release motions is how they've been called. There's a move to call them reduction in sentence motions because it more appropriately like captures what they're about. And I think people tend to associate compassionate release with like people dying. And really what's interesting about the statute is it doesn't talk about that at all. It just talks about extraordinary and compelling reasons. And this new policy statement enumerates a lot of non-medical reasons that are extraordinary and compelling, like sexual and physical abuse in prison, extraordinary family circumstances. It now includes this unusually long sentence provision.
And I'll get on my high horse at this moment about the lingo because, my sense is your clients are a spectacular example of people who are not asking for compassion. They're asking for justice, right? They're asking for equity. They're asking for equal treatment. They're asking for a just outcome in light of the fact that a whole cohort of others just really as a matter of timing got much, much lower sentences. And ultimately, they not wrongly believe here's a mechanism to tell these compelling and extraordinary stories and get justice done. That's why I'm on sort of team, let's call it sentence reduction motions rather than compassionate release motions, because I do think that labeling of compassion makes it sound like you're asking for something that's not deserved and shouldn't be expected. I understand why they're fighting, and this is a little technicality. Oh, Congress didn't make this law retroactive, so you shouldn't get the benefit of this law if you don't fit the technical categories. But your clients have that on top of this history of stash house stings that have this pernicious racial disparity and all the other uglinesses that are part of it.
Right.
To me, that should be a no-brainer of, okay, well, this cohort at least has an extraordinary story. And I think the judges have largely agreed with you when it gets to that point, right?
Yeah. And we raised for many of our clients the non-retroactive changes, which was the issue of the circuit split, whether those could be extraordinary and compelling. And in the Seventh Circuit, before the judges decided our motions, the Seventh Circuit said those are categorically barred from being an extraordinary and compelling reason. So we really did have to lean into this combination of factors, the sentencing disparities, the pernicious nature of the stings, the fact that the government wasn't charging them anymore. We also raised other arguments relating to our clients' health issues, like anything that we felt like could really strengthen our arguments. And once, we started to get decisions, we thought these were strong arguments, but these non-medical grounds were very new. They were untested. And so we really didn't know where these were going to go, especially once we lost the case in the Seventh Circuit is Thacker, which barred the non-retroactive changes. And we were just overjoyed when we got our first grant, actually, for our client, Dwayne White, who was Leslie Mayfield's co-defendant. He was serving a 25-year mandatory minimum sentence. The judge granted the reduction to time served, which was about 12 years. And then we had two other clients their motions were granted, and they were also released, both also serving 25-year mandatory minimum sentences. And so the judges were agreeing with our arguments. And so we just kept filing the motions. We had thought about, we had the whole list of people who were still in prison. We had information about whether they had these 851 sentencing enhancements. We had more information about their cases. So we just kind of kept going down the list.
I'm curious if you all saw an interplay between the judges considering the compassionate release or reduction in sentence motions and those who had heard the evidentiary hearing when the racial disparity claims were being litigated. Do you notice a difference? Do you sense that the judges who were at the heart of that litigation were more sympathetic? Or is that just one of a lot of things that they listen to because at the end of the day, they're ironically maybe concerned about releases creating a precedent and suggesting that there are all these, as you mentioned, non-medical reasons that could be the foundation for sentence reduction?
That's a really interesting question because of the judges who have decided these motions, two were sitting, the district court en banc and heard all the evidence, heard the experts and all of that. And I do think it was impactful. I think having had the background, having seen firsthand, they were also then involved in people getting these lower sentences. So they had also seen how that had happened. And I think in their own minds, one of the judges here wrote it was actually the first compassionate release reduction in sentence grant in the Northern District of Illinois after our litigation. It's called United States versus Conley. And if you read it, the opinion is just scathing. And part of it is the Judge Coleman, having seen what happened to people who were part of our litigation and then what happened to people who were left behind, and the real injustice of that. So I do think that the work that we did on the compassionate release reduction in sentence side would not have been possible, obviously, without, it was just the foundation of that was the litigation. After the first 3 releases, we had 3 more Stash House clients released since then. 2 were just released this summer. And then there was a whole other cohort of Stash House guys who were released during the COVID pandemic. So the extraordinary and compelling reason was vulnerability to COVID, but they were also in the Stash House cohort. So there's now been a total of 11 of the 40 plus people who have been released under the sentence reduction statute, and truly seeing them come home, reunite with their families, hear about all the amazing things they're doing. There's just nothing better than that for us and our students. I'm
sure you guys could tell literally hours of narratives about individual persons as well, because, that's part of what makes this work both so meaningful and so challenging, as you were talking about, Erica, just seeing people come home and, this is people locked in cages and having a very strong argument for why they shouldn't be. And, getting courts, getting prosecutors, getting the system to pay attention. It's fascinating to hear. What I know is just kind of the tip of the iceberg, but we're incredibly grateful for you all sharing it with us.
Yeah, there are so many, I think, really powerful threads and, that run through all of this.
I don't want to overlook this, that only 3 men from the cohort of people who were not able to take part of your litigation. So 3 out of 94. So 91 people are out. Either they served their time, unfortunately, but many of them were released, at least a decade earlier than they would have been. So there are only 3 men.
3 men left. Many have been released within, just because they've, unfortunately had to serve their entire sentence. They've been released within the last 1 to 2 years. There's 3 people left, and we're representing 2 of them to try to get them out on the Stash House reduction in sentence arguments. So the Sentencing Commission finally got a quorum, and one of the first things that they had to do was address the reduction in sentence policy statement, because Congress had tasked them with deciding what's extraordinary and compelling. They had this really tough job of deciding what should the policy statement look like with these changes. And so they held hearings, they received literally thousands of public comment on this issue.
And you testified too, correct?
I testified. One of our clients testified. Dwayne White, our first client, released. His story, it just encapsulates everything both that's wrong with the Stash House stings, and then that was also so wrong with all the people that were left behind serving, these incredibly long sentences. He was somebody who was asked the day of by Leslie Mayfield to come along.
And Leslie Mayfield was part of your litigation in the Seventh Circuit. Okay.
So he had the fortuity of being part of our litigation because his conviction got reversed after trial. So it was so many things falling into place. But what we saw was Dwayne was recruited by Leslie at the last minute. I really don't think Dwayne knew exactly what was going on. So he gets to the sting, the arrest point, and the agents had never seen him before. They were wondering what was going on. Dwayne was 21 years old at the time. So they give the call to do the arrest. He's arrested along with everyone else. And suddenly he has this litany of mandatory minimum charges against him. He's got this 851 for simple possession from when he was a teenager. He got a 15-year plea offer that he turned down because his girlfriend, he found out when he was in prison pretrial that she was pregnant, and he just couldn't get his mind around the idea that he was going to serve 15 years mandatory for showing up for this reverse sting. So he also testified in front of the Sentencing Commission as really kind of the quintessential, non-medical reduction in sentence grant. This idea that you could have this constellation of circumstances that are extraordinary and compelling. And his panel, there were 4 other individuals who formerly incarcerated who had also received reductions in sentence. And it was the most powerful panel just hugely, hugely, I think, impactful on the commissioners. It was the first time the Sentencing Commission has ever had formerly incarcerated people testify. And I think it really went a long way towards showing them the importance of compassionate release and reduction in sentence, and the importance of giving judges discretion to decide what is extraordinary and compelling.
So the commission ultimately expanded the grounds for release then?
They did. They expanded them in some really, I think, groundbreaking ways. So one question that the commission had to address and weigh in on was this circuit split about whether non-retroactive changes could be extraordinary and compelling. Because this was something like, if you're in the Seventh Circuit, you can't get relief if you're arguing that these, legal changes in your case are extraordinary and compelling. Whereas if you were in the 10th Circuit, the 4th Circuit, the 9th Circuit, people were getting out. So it is just this geographic disparity and injustice that the commission, had to address. And the way that they did it, I think, was very interesting. They ultimately promulgated this unusually long sentence provision. So they don't come out and say, non-retroactive changes are extraordinary and compelling. What they say is that an unusually long sentence where someone has served at least 10 years in prison, there is a gross disparity between the sentence they received and the sentence they would receive today, and the person's individualized circumstances support relief. All those things are satisfied that it may be an extraordinary and compelling reason. So it's much, much, much narrower than the legal question that judges were deciding, prior to the policy statement being enacted. Nonetheless, the government has I think, very disappointing nationwide litigation position of saying that the unusually long sentence provision is legally invalid, that the commission overstepped its authority in promulgating it. So that litigation is playing out, in the courts right now.
How do you feel about the outcome of that?
I think there's going to be a circuit split on this issue, and it's probably going to have to be decided by the Supreme Court. I mean, I think on the merits of the argument, I don't think the government has a strong argument. They have a policy disagreement with what the Sentencing Commission did, that they are trying to litigate as a legal issue. They are saying that Congress, in spite of not saying it, really meant that the Sentencing Commission couldn't describe extraordinary and compelling reasons, or that there are these, extra textual limitations on what the Sentencing Commission could do, when in fact, Congress was very clear about what the commission could do. It said they describe extraordinary and compelling reasons. The only reason that is off base is rehabilitation on its own. So that's the only thing that Congress said. They didn't say non-retroactive changes are off limits. They didn't do anything like that. I think the reality is that some judges in the circuits where the bad circuits, I call them, like the Seventh Circuit, where we haven't been able to bring these motions until the policy statements took effect, I think judges are going to be wary of granting these motions. They're going to want to see what the Seventh Circuit thinks. So those cases are all, making their way, or we'll see how district judges come out. In, the good circuits where compassionate release and reduction in sentence was fairly broad, we're seeing already, grants under B6, the unusually long sentence provision, for reasons that are broader than non-retroactive legal changes. So case-related legal changes. So it's going to be, what circuit people are in is going to be determinative. I hope, pray that this issue comes out the right way, because what the Sentencing Commission did was absolutely legal. It's good and sensible policy reform. And I think it's beyond disappointing to see the Biden DOJ essentially go after the Biden Sentencing Commission, who really put a lot of thought and care into this policy statement. So that's one change.
It's one thing to think about just black and white, Department of Justice, prosecutors, bad guys, and then defense, good guys over here. But then that political element just does make it baffling, because you have a Biden DOJ with like you said, a Biden Sentencing Commission duking it out in this way, or at least not being aligned. I wonder, does administration changes halt DOJ efforts in their tracks? Are you afraid one way or the other that if it's a non-Biden DOJ, do you think that it's going to carry on? Do you think that the policy statement will change with a change in administration?
I mean, I think it could. I think that the promulgation of the compassionate release policy statement was divided. It was, the commissioners came out on it 4-3. And so the legal arguments that the DOJ is making right now are essentially the arguments that the conservative commissioners made when they were objecting. And they weren't objecting to the whole policy statement. I think that there were other changes that were made, like I mentioned, sexual and physical abuse in prison. The enumeration of that is an extraordinary and compelling reason, which is also very groundbreaking. It was something that was not in the previous policy statement. And was the result of a lot of advocacy by a lot of different groups to bring that to the fore. But I think the unusually long sentence provision is going to be a hot potato. I think it's going to be a hot potato in the courts. I think, it remains to be seen what might happen if there's a new, administration. There's a sentencing commission that goes 4-3, Republican. But I think it does get harder once there are more decisions that judges are making granting releases. Something that I've talked to Doug some about is the catch-all provision, which I think it's going to be extremely interesting to watch that provision going forward. So this was always a part of the Pre-First Step Act policy statement. It allowed the Bureau of Prisons to move for a reduction in sentence for other reasons. They could be related to the enumerated reasons or not. And there was a fight over whether they should keep the catch-all and what it should look like. And ultimately, the commission did keep it, and it's fairly broad. So the Stash House motions that we're going to be bringing, we're bringing those under the catch-all. It's these combination of extraordinary and compelling reasons. And it was really the Sentencing Commission's acknowledgement that it would be impossible to enumerate everything that judges might find to be extraordinary and compelling.
Seems like a really subjective standard.
It's super subjective and it's super individualized, both on the extraordinary and compelling reasons. And then also, that's just the first step of the process. You also have to convince judges that the sentencing factors, support and warrant release, and that your client is not a danger to the community. So a lot of motions, even if they make it past the first stage, don't make it past that stage. So I think, there are going to be a lot of grants under the catch-all. And that is also, I think, a way that judges might insulate what they're doing if they're worried about doing a grant on the unusually long sentence ground. I think many judges may say, I'm also granting under B5 because there's this combination of extraordinary and compelling reasons.
I think these motions fundamentally are motions to encourage judges do equity with the benefit of hindsight. And that's where this kind of litigation, all the other flaws and uglinesses that are in our criminal justice system get exposed. And that's among the reasons why the Department of Justice is like, no, let's not look over there. I don't want to suggest any way that they're inherently the bad guys, as much as I want to kind of highlight that this is no fun for them. Putting away the bad guys is what's fun for them. Having to confront, deal with, particularly when they're very effective advocates for prisoners, here's all the things that looked ugly in your case. And oh, by the way, there's no good reason to keep this person in prison, that they have to respond to that they have to respond to that on every possible ground, rather than can try to argue as they did to the commission, but lost. Oh, don't let somebody ever bring this kind of argument to get in the door for this kind of reduction. And so I think it's, again, to me, why it's so valuable to tell both parts of the story, the incredible work that the clinic did to explain how problematic these prosecutions have been, and then also to highlight that the compassionate release statute, the reduction in sentence statute, now provides an opportunity to highlight that, and yet creates all these challenges and depends on what the Sentencing Commission has chosen to do with its policy guidance, what the Department of Justice has chosen to do in response to these kinds of cases. And so I'm incredibly grateful. We've covered so much ground on so many hot topics in not much more than our usual amount of time. I certainly feel like we've covered so much so well. I want to make sure either of you get a chance to say a last word, or make sure you cover something that may not have been covered.
I was just going to say, thank you so much for having us on to talk about these cases, the injustices, the litigation that we and the federal defenders in Chicago and others did. I've always had so much admiration for you, Doug, and for the work that you did. I mean, back when I was a pretty new federal public defender in the mid-2000s, it was your work about federal sentencing that really helped us fight for justice for our clients, in the midst of Blakely and Booker and all of that. the writing that you were doing on it, your blog. I mean, it was something that on a daily basis, federal defenders across the country were reading and using to advance our arguments. And so I'm very honored to be on this program. Thank you.
I completely concur with Alison on that. And I don't honestly know how you do it, how you reduce the amount of content you do, that you teach and that you do this. But your blog is like the first place I go when I want to know, what's happening, both with like the compassionate release reduction and sentence stuff, but everything sentencing related. It is an absolutely huge honor to be on this. And I feel like I could talk to you guys for another hour. So I know we don't have that time, but I guess one thing, Doug, I think your point, the last point you made about these motions it's just so on point. And I think there is an education process that federal judges are undergoing by reading these motions. And that's why I think it is so crucial that people have lawyers, which is not happening in the Seventh Circuit, appointed lawyers. But like, these are stories about what happens when federal judges sentence people to prison, stuff that none of us were hearing about. Like, when I was coming up as a federal defender, these weren't motions we did. So I didn't hear, about Bureau of Prisons, like what was happening. And it's, it's pretty horrifying. And I think there's some judges who are never going to want to use this. The Sentencing Commission has given them like, you have to, but they're going to find ways not to. But I think for judges that have the humility to look and say, we may have gotten this one wrong, or even if we didn't get it wrong, the person has served what they need to serve. Like any additional incarceration is unnecessary. I think it is such a valuable contribution to making our system more just and fair.
Drugs on the Docket is a production of the Moritz College of Law Drug Enforcement and Policy Center. This episode is produced by me, Hannah Miller, and Holly Griffin. Doug Berman is our editorial advisor. The music is composed by Joe DeWitt.